We are now on the 6th lesson since the page was launched, and the team are very thankful of the constant support of the likers and followers of LexClassroom on our FB page and also the subscribers in our YouTube channel. Now, we start with our lesson. It is about the 2004 Rules of Notarial Practice. I find this very important to share here because being a notary public myself, I consider that I have the responsibility to help not just the law students, those interested and could relate the law, but the general public who one day in their life would go to a notary public. So, this lesson is composed of questions that would clarify things and highlight the important points of the 2004 Rules of Notarial Practice. To guide you, these are the questions that we will be answering throughout the lesson. 1. When is there a need of a notary public? 2. What are the notarial acts allowed by the 2004 rules? 3. Who is a notary public? 4. What do you need to have if you are a party to the private document when you go to a notary public for notarization? 5. What is the indication that the document you have has been completely notarized? 6. What notaries public cannot do? And 7. What are the safeguards that the public must take note to avoid any legal concerns relative to the notarization? To answer the first question, generally, one needs a notary public if and when a person wants a private document be transformed into a public one, which could be relied upon by the other people, especially the government. These private documents could be contracts, affidavits, statements, and other documents required by law that must be notarized. Example, applications submitted to government agencies like the Social Security System, Office of the Building Official, Securities and Exchange Commission, Department of Environment and Natural Resources, and Embassy or Consular Office. Second question is answered by Rule 4, Section 1 of the 2004 Rules of Notarial Practice. It says that a notary public is empowered to perform the following notarial acts. 1. Acknowledgements. 2. Oaths and affirmations. 3. Jurat. 4. Signature witnessing. 5. Copy certifications. And 6. Any other act authorized by these rules. To have better understanding of this legally loaded provision, acknowledgements are found in contracts. It looks like this. A jurat looks like this, and are found in affidavits or sworn statements. Copy certification is applied when a private document is reproduced in several copies, like a photocopy of an acknowledgement receipt after payment of a debt. For question number 3, a notary public is one who is qualified by law to do the notarial acts mentioned. So, to answer this, we must know the qualifications of a notary public. Rule 3, Section 1 of the 2004 Rules of Notarial Practice provides that to be eligible for commissioning as notary public, the petitioner must be 1. Must be a citizen of the Philippines. 2. Must be over 21 years of age. 3. Must be a resident in the Philippines for at least 1 year and maintains a regular place of work of business in the city or province where the commission is to be issued. 4. Must be a member of the Philippine Bar in good standing with clearances from the Office of the Bar Confidant of the Supreme Court and the Integrated Bar of the Philippines. And 5. Must not have been convicted in the first instance of any crime involving moral turpitude. So, the compliance of these strict requirements presupposes that all notaries public in the Philippines are lawyers, but not all lawyers are notaries public. It is not like in other jurisdictions in which a notary public could be any person qualified by their laws, but there is no need to be a lawyer. In fact, the person who wants to be a notary public must file a petition before the Office of the Executive Judge to establish his or her qualification as a notary public in the Philippines. For better understanding of the requirements, especially those law students, you have to read the full text of the 2004 Rules on Notarial Practice. For question number 4, if you're a party to the document, you must have 1. The original copy of the document. If the document you want notarized is a contract, actually the notary public can also help you in the drafting. However, the drafting is of course separately paid. In another lesson, we will discuss the rates of a lawyer's professional fees. 2. You have to have a competent proof of identity. You must take note that a cedula is not considered a proof of identity. Also, the barangay certification. Examples of acceptable competent proof of identity is your valid government identification cards like passport, SSS ID, voter's identification card, PRC identification card, driver's license, your UMID, among others. When you say valid, the identification card must not be expired. You must take note that if you want a contract notarized, you must bring along with you witnesses to the contract. The witnesses must not be parties to the contract and not related to the Notary Public who is going to notarize the contract. Among the restrictions related to this will be discussed in the answer to question number 6. Before we continue answering the questions left unanswered, we will take a break first. Stay and you will know the answer to the rest of the questions.